Good afternoon, everybody. My name is Dana Lawrence. I am the Fair Hearing and Administrative Procedures Manager for the Regional Center, which means that my department handles all of the appeals, all due process, all 4731s, which are rights violation complaints, which we'll talk about a little today. We also handle all the vendor complaints, devendorization, and fiscal audit appeals, as well as early start complaints and hearings. So we do a lot in our department, but to get you sort of a little bit more information about the rights under the Lanterman Act, which is what we're going to talk about today. Again, in some agencies, this is called due process. They're the rights under the Lanterman Act. We're going to go through a brief presentation. I'm joined today by Gabby Ashrati. Gabby, do you want to go ahead and introduce yourself real quick?
Yes, thank you, Dana. I'm Gabby Ashrati, Director of Consumer Services for our Antelope Valley office and for our Santa Clarita office. I thank you for joining us today and understanding a little bit about our service systems and the rights under Lanterman Act.
Okay, so we're going to go ahead and kick off our presentation. Okay, so what is due process? Due process is a right to our consumers and their families under the Lanterman Act that guarantees that issues or disputes between the regional center and vendors or the regional center and consumers will be handled fairly. And there's a whole process that's in the that's written into the Lanterman Act for this. So there are several types of due process. And I mentioned that these are things that my office within the regional center handles. They include Lanterman appeals. Those are for appeals regarding disputes of the amount, termination, or reduction of services for people who are either over the age of 3 or for our status 2 early start consumers who are Lanterman consumers as well. We also do fiscal audit appeals. Those are against vendors. We do vendor appeals, vendorization appeals. My office handles all early start mediations, early start hearings, and we also do Lanterman 4731 complaint investigations. So this shows that they are due process venues for not only our consumers and their families, but also our vendors. There are a lot of rights that are written into the Lanterman Act for our consumers. Our consumers, of course, they have the same rights of anybody who's here in the United States, and they have the rights that are written into the California Constitution as well. But the Lanterman Act goes a little bit further and enumerates rights specifically for our consumers. I'm not going to read all of these, but if you see where it says Welfare and Institutions Code, Section 4502, that's what I'll be referring to today. We call the Lanterman Act also Welfare and Institutions Code. So just to not confuse anybody on that. So the Lanterman Act guarantees the right to treatment and rehabilitation. Those are the services and supports that are included in an agreed upon IPP document. Our consumers are granted the right to dignity, privacy, and humane care. So that means that they have a right to be respected by those who are providing services and supports to them. They have a right to receive those services and supports in the least restrictive environments. A right to prompt medical care, a right to practice the religion that they choose, and a right to interact with those they choose to interact with. They also have the right to have exercise and recreational opportunities. Of course, we want our consumers to also be free from harm, including physical restraints and isolation, excessive medication, and to be free from hazardous procedures, which means that we won't do anything experimental, or we won't fund anything that's experimental for our consumers. They have the right to make choices in their own lives. Yes, this includes our adult consumers, even though their family might be representing them. Our adult consumers do have the right to speak for themselves and to make choices in their own lives. And they have a right to investigation of any possible abuses. There are additional rights that are granted in the Lanterman Act. Again, Code Section 4502.1. They have the right to have their choices to be respected. And several places within the Lantern Act, you'll see that our consumers and their families have the right to have the information provided to them in the language of their choice, which means that we might have to translate a document, or we might have to provide an interpreter or somebody who speaks the language of our consumers. Our consumers who reside in CCFs, which are community care facilities, or that are in state hospitals, also have a special set of rights designated just for them. They have a right to wear their own clothes and have space for their storage. They have a right to access telephones and make telephone calls. And that right means that they have a right to confidentiality when making those telephone calls. They don't want somebody standing right next to them while they're making the phone calls, then they have a right to ask that person to move away. They have a right to writing materials, to write letters, and to refuse certain types of treatments. Um, they also have the right to make decisions regarding how they live their daily lives, who they hang out with, who they interact with, and how they spend their time. The entire purpose of the regional center is to help alleviate developmental disabilities, and the way that we do that is by providing services and support. And um, uh, there is a right to additional support within the Lantern Act, which support in accessing benefits, healthcare, housing, special education. So while there are other agencies that provide advocacy and advocacy assistance, Regional Center is sort of the first stop for that advocacy assistance. And if it's something that the Regional Center can't do, then we look outward for other advocacy assistance in these areas. There's a right to have a designated service coordinator and a right to assistance in accessing community. If you are applying for eligibility, there are certain rights written into the Lantern Act regarding the time that the regional center has to make eligibility decisions and take eligibility actions. There is a right to eligibility determination within 120 days. And that is reduced to 60 days if there is a risk for injury to be caused if the regional center were to take the additional 60 days on top of that. Even within the intake process, you have a right to receive communications in the language of your choice. If you are found eligible at North Los Angeles or any other regional center throughout the state of California, you are then eligible for services from whatever regional center area you live in. You do not have to go back to the eligibility process just because you might have moved out of the North Los Angeles area. Eligibility will continue unless there's a determination that the eligibility was clearly erroneous. You have a right to have a smooth transfer. So say you're moving from the North Los Angeles catchment area up to the Bay Area. You have a right to have a smooth transition of your services and supports from one regional center to the other regional center. If you were to move to another regional center and your case is transferred to them, they'd have to immediately review your IPP document and determine if the same services that you were getting at North Los Angeles are available in the Bay Area. If they're not available in the Bay Area, we have to have a meeting. There must be an IPP meeting within 30 days in order to determine what services and supports the new regional center can provide to you. Once you're made eligible, you have a right to have your first initial IPP meeting and draft within 60 days. that IPP should be individualized and should always consider your needs and preferences, and you have a right to be provided a copy of that IPP. Our consumers have the right to marry, be part of a family, have relationships, and of course, in some cases where conservatorship is a factor, some of our consumers' individual rights may be curtailed a little bit. So this is basically talking about an adult consumer who is not conserved, and so nobody has the right to limit their rights. Our adult consumers have the right to have independent living services to foster their independence and make them able to access our community in a better way. To have customized day services to meet their needs, to live in their own home, should they choose to, with or without supports, to be provided information about options, living options, and the right to have their quality of service monitored. Okay, I'm going to pass it off to Gabby for the next few slides.
Thank you, Dana. I'm going to be reviewing with you the Welfare and Institution Code, Section 4646, 4646.5, 4647, and 4648. This is in regards to the rights related to individual program planning. You have the right to participate in that process of the IPP. If you are a new member of the regional center, the initial IPP needs to take place within 60 days of being made eligible. You have the right to an individualized IPP considering and reflecting needs and preferences. The right to service supports to help integrate into the community. To have goals and objectives, services, and supports included in the IPP, to be provided with a list of agreed upon services, supports, the frequency, duration, and the provider, as well as the start time if it's determined at that meeting. The individual has the right to be provided with the individual program planning report, the right to be notified of IPP meeting in writing if they request, to reconvene within 15 days or later if agreed of the IPP for a final agreement of services and supports, because a decision cannot be reached during an IPP meeting. The right to state disagreement with services and supports when signing the individual program plan. The right to receive agreed upon services, even if there is a disagreement. So this may mean that we agree upon some services, but others are disagreed to. So we would proceed with the agreed services to provide those. The right to have a language preference noted in the report. The right to have a need for extraordinary care, services, supports, and supervision taken into consideration for individuals we serve who are minors. Continuing on with those same regulations, the individual has the right to a written copy of the individual program plan to be provided within 45 days in the language of preference. The right to regular and periodic review of that plan. For individuals living in the family home, it's a minimum of every year. For individuals living in facilities or independently, it's a minimum of every 3 months. The right to review the IPP within 30 days of a request or 7 days of a request if necessary for health and safety of consumer. The right to have a service coordinator, and the right to request a change of service coordinator. That notice is provided within 10 business days to the individual making the request. The right to new service coordinator if requested. The right to service supports and those be included in the individual program plan. The right to flexible and individualized services and supports. To have choice of service providers being considered. And if crisis in crisis have crisis and emergency services. The right to assistance in accessing generic resources and supports, and to be informed about the appeals process. Some more about the IPP process. As we mentioned, there are timelines that I explained previously, along with notifications. And some of the factors of making decisions by regional center is that we would need substantiating information, maybe some school records, medical records, and all the information that we need to make decisions, depending upon the service being requested or in need. Exception of services are also made to provide supports, and this is generally for extraordinary circumstances. Extensions of timelines are also made depending upon the need for possibly a service to be continued or a service to be extended because it wasn't completed. Factors resulting in delays in regional center decision could be that we have to do an assessment or we need additional records, but each case is individually different. Some service approvals: if a service is identified through IPP planning and the agency provider has staff available for services, services coordinators can create a purchase of service with a start date at any given time throughout the month. Service implementation must receive, in order for us to provide service implementation, we must receive completed IPP signature page prior to the purchase of service creation and service implementation. Welfare and Institution Codes 4700 and 4716 gives the individual the right to adequate notice in writing when regional centers takes an action that consumer does not agree with, a notice of proposed actions, or otherwise called NOPA or NOA. This particular notice provides a statement of basic facts, actions regional center proposes to take, reason for those actions, the effective date of those actions. It must be 30 days from the date of the notice, the specific law, regulation, or policy supporting that action, and then it provides you the ability to file an appeal, receive notifications of rights to appeal. The notice of action must be certified mail within 5 days of regional center decision, right to file for an appeal within 60 days of receiving notice of proposed action, right to have services continued, which is called aid paid pending, if that's a service that's currently in place, if appeal is filed within 30 days of receiving the notice of proposed action. And on the monitor, what you're seeing is when you do receive a notice of proposed actions, you will receive also a form to file an appeal. And that the form on the monitor is what you're seeing, where you would file an appeal. It provides you on how to file the appeal, where to get help. The actual appeal notice is next to that, where it asks for the primary information. If you would like to move forward with an informal meeting, a mediation, or a hearing. The next parts of the form provide with the reason as to why you're appealing and some additional specific information. We've also included the form in the presentation, both in English and in Spanish. And now I will hand it off to Dana, who will continue with rights related to an appeal.
Okay, so once you file for an appeal, as of March 3rd of last year, you filed those appeals directly with DDS. Once you file for an appeal, you get another set of rights related specifically to that appeal. So you'll have the right to be present at the hearing, to present evidence, written or oral. So that means you can provide records, or you can have somebody come and testify on your behalf. If the regional center has witnesses for the hearing, you also have the right to cross-examine those witnesses. You can have anybody represent you in this appeal that you choose. It does not have to be somebody that's related to you, but it can be. It could be somebody that you trust would be able to do the best job for you in this appeal as possible. That means you can have an advocate or an attorney as well. Um, you have the right to request records from the regional center. And once you are in the appeal process, if you request those records, we must produce them to you within 3 days. You have a right to an interpreter during the appeal process, and you have a right to receive information on advocacy assistance. That advocacy assistance is actually provided to you when you get your notice of action in the mail. Gabby already talked about the aid paid pending. You do have a right to have services continue, Lanterman services continue during your appeal if you file for that appeal within 30 days of receiving your notice of action. There are several parts of an appeal that you can participate in. The first being an informal meeting, and that is just a meeting sitting down with somebody from my department to discuss why you appealed and why you think that the regional center made a erroneous decision. If you request an informal meeting, that meeting should be held within 10 days. Following that meeting, my department will write a letter to you outlining what we discussed in the meeting and telling you what regional center's decision is at that time. For Lanterman appeals, you have a right to request a continuance. As of March 3rd of last year, you can request the first continuance for any reason. You do not need to have good cause to request that first continuance. You have a right to have a hearing within 50 days of filing your appeal with DDS, but that might be extended if you choose to participate in a mediation or you choose to have an informal meeting after you've already filed for that appeal. And then once the appeal is heard, once a judge hears the case, you have a right to a decision from that judge within 10 days. So apart from appeals, there's also another due process procedure which you can engage in. And this is specifically not for the termination, reduction, or denial of services and supports. This is specifically when you feel that the consumer's rights have been violated. And so you have a right to file what's called a 4731 complaint. And I'll show you the forms in just a moment for that. They can be found on our website. This is when you feel that the consumer's rights have been violated. What the regional center has to do once we receive that complaint is we have 20 working days to reply to that complaint. During those days, we'll do an investigation. We'll review all the documents that you provide and all the information you provide in your complaint. We'll talk to the regional center people or the vendors that may be involved in that complaint. We'll weigh the information that we've received against the statute and determine if we believe that your right has been violated or not. If we believe that your rights have been violated or the consumer's rights have been violated, we provide a proposed resolution. And generally that is more training for either the vendor staff or the regional center staff. If you receive a 4731 response from my office and you disagree with the findings, you do have the right to appeal those findings within 15 days. And in the letter that you'll receive from my department, that information will be provided exactly where you are to file your appeal. DDS then has 45 days to review everything that was included in that response and in your complaint, and make a second determination on whether your rights, the consumer's rights, have been violated or not. You are entitled to information about these 4731 complaints and the right to file a 4731 complaint at certain times during your time with the regional center. You're supposed to receive that information when you apply for services or when you're admitted into a developmental center or at each scheduled IPP meeting. Again, 4731 complaints are not to be used for the purpose of disputes regarding the nature, the amount of services, termination, when regional center declines to fund for things. Those are specifically not allowed to be investigated as part of this complaint process. So here's the 4731 complaint form that you can find on the regional center's website. You just put in who is filing the complaint and who the complaint is for. And then here you'll give us some basic information about what you're complaining about. If this area is not large enough, you are more than welcome to provide additional pages with your complaint. We also welcome you providing any sort of evidence that you have to back up your complaint, whether that be in emails or whatever form. And again, you can file a complaint against the regional center or a vendor of the regional center. This is the complaint form in Spanish. So I already talked a bit about the process. This again is just a review of the process. We received the complaint. We will send you an acknowledgement of that complaint. We will schedule our meetings to further investigate the complaint. We may have questions for you once you file the complaint, or if you've given us enough information in your complaint and additional pages, then we might not need to contact you. But if we have any additional questions, we would contact you. We interview the necessary people. Those might be regional center people. They might be vendors. Gather all the relevant information and review it. We are responsible for researching the law, drafting a response. All responses are reviewed by our executive director and signed off on by our executive director. We will translate the response into your language of choice. However, due to statutory constraints on our timeline, we only have 20 working days to provide our responses. And most of the times, this will not allow for translation. So we will send you the English copy, which is the official copy. We will send the response letter off for translation and then send that letter to you once it has been translated by an agency. So these are some sources of information that we look at when we're investigating 4731 complaints. We can look at any or all of these. And again, you can feel free to provide us as much information as you see here as you have that you think will be helpful to our investigation. Here is where you find the forms that we've already reviewed as part of the presentation today. So forms are located under the Consumer and Family tab. You just go down to the complaint process, and there you're going to find the forms. Forms are also available on the DDS website. And this is our page in Spanish. And here you will go back under the Consumers and Families tab, and here's the complaint process for you right there. Before we get to questions, I did want to review the notice of action form because I neglected to put it into the presentation, and I truly apologize for that. This is a new form to the regional centers as of March 3rd of last year. And this is the form that you'll now receive when the regional center is terminating, denying, or reducing a service or support that you've requested. Previously, the regional center used to write a letter to you in order to make things, attempt to make things the same throughout the 21 regional centers in the state of California. DDS has created this form for us to use. So you're going to see the consumer's information here. You're going to see one of these checked, and the options are eligibility denial, eligibility termination, service denial, reduction, or termination. So one of those should be checked. And the date of the proposed action that will occur. Again, Gabby already said that that needs to be 30 days from the date of the notice. Here you're going to see the proposed action, what regional center is proposing to deny, reduce, or terminate. Why we're doing this, so our reasons that we're going to deny, and then the facts and laws supporting that decision. Here you're going to see what statutory section applies to this denial, reduction, or termination. And again, you're going to have your rights to appeal. And this is where it tells you the rights to appeal. And then I mentioned earlier that you will receive advocacy assistance information with your notice of action. And this is where that advocacy information is found. You also have the opportunity to go to the DDS website. They have put together compiled information about the appeals process for you. You can either use this QR code, you can use QR codes, or you can follow this link directly to the DDS website to get that information that they've compiled.